Okay, everyone, we are about to examine the last branch of government that we have to explore, the judicial branch. I hope that you can hear me okay. My backyard is currently the quietest place I have found to record this because my fiance is yapping on the phone really loud. There's traffic in the background, but hopefully we can get her done. Okay, so first we need to talk about the two different types of law that exist in our country. We have criminal and civil law. And criminal law is when the government charges an individual with violating specific laws. And there are many more differences, but one of the biggest is in a criminal case, a jury is going to render a verdict of guilty or not guilty. And in order for a defendant to be convicted of guilt, the jury must find that the defendant is guilty beyond a reasonable doubt, meaning that there's no other possible explanation for the crime other than the defendant committed it. In a civil case, this is when there is a dispute between two parties, one of whom might be the government itself. It can be two individuals. It can be an individual and a business. And the issue at hand can cover a wide range of matters. In a civil case, a jury is going to make a determination of the preponderance of evidence, meaning is the defendant in the case liable for damages owed to the plaintiff or the suing party. Criminal cases are probably, as you might guess, far more interesting. If I had to be a juror on either a criminal or a civil case, I definitely would choose the criminal case. I always try to think of interesting examples of civil cases. I would say probably some of the more interesting ones would deal with intellectual property. So if you've seen the movie The Social Network, and how Mark Zuckerberg had 3 different pending lawsuits. Each of those was a civil case, people claiming that he stole their idea from their brain. Also, a year ago, Apple settled with Samsung for some ridiculous damage amount, and damage is always going to be money, for, again, IP or intellectual property theft of a certain part or patent in a phone or something silly. Okay, so the fact that we have different types of courts, specifically a federal and a state court system, speaks or is called our dual court system. So states have their own criminal court system, completely operated by the states, and then those courts are going to be separate from our federal courts. But they're still linked by appeals processes that allow them to challenge state law in a federal court. And there are different reasons why a case would be tried in a state court rather than a federal court. As you might imagine, trials taking place in a state court deal with violations of state law, where trials involving federal, or that take place in federal courts, deal with federal laws. However, if a state court decision is appealed, it can make its way to a federal appellate court, including the top dog, the Supreme Court. When we use this word jurisdiction, what are we talking about? Jurisdiction means the authority of a certain type of court to hear the case. So there is original jurisdiction, and original jurisdiction of courts that hear a case first, usually in a trial. So original jurisdiction is where the case was originally heard. So when we go on our courthouse field trip, and you guys are watching a case, whatever court we are in, which would be the San Diego Superior Court, that would be the court of original jurisdiction. And it's in those courts where people, the jurors, the judges, determine the facts about a case. An appellate court, or a court that has appellate jurisdiction, are courts on the next level of our justice system. These are courts that hear cases on appeal from lower courts. So the lower courts, a state court, a county courthouse, whatever the case may be, makes a decision, makes a ruling. If there is an appeal, that appeal would go to an appellate court, and so those courts would be the ones that have appellate jurisdiction. In these courts, they do not review factual records, so they don't go back and say, okay, well, this piece of evidence shows that he actually wasn't guilty. Rather, they are evaluating legal issues involved. And those legal issues can include looking at whether a piece of evidence was permissible or not, but they aren't sort of retrying the case to see if he or she was guilty or not guilty. There are different types of federal courts, district courts, courts of appeal, and Supreme Court. So just like on the state court system, district courts would be the federal courts that originally hear a case involving a violation of federal law. There are also federal courts of appeal, and this is when, if a decision is appealed, then federal appellate courts would review the legal issues involving the case. And then the highest type of federal court that we have, and the court of last resort, as it's known as, is our Supreme Court. Okay, so district courts are synonyms for federal courts. There are 91 federal courts of original jurisdiction, meaning that if there is a situation that has violated federal law, that case would be tried in one of 91 federal courts around the country. There are only federal courts with jury. They are the only federal courts with juries and trials. And about 98% of all criminal cases in the U.S. are heard in state courts, not federal courts. I think a lot of times what I've learned from students is that students hear the word federal and they assume that it means really important or high profile or significant. But probably, and as the statistic supports, the majority of cases that you could provide for me as examples are going to fall under state jurisdiction. So murder, arson, rape, sexual assault, robbery, I think I already said arson, but all those crimes that often get a lot of attention and are considered high profile, they are actually state cases. Interesting. So federal courts can deal with some of those same topics. So for example, kidnapping cases where the kidnapper takes the victim across state lines, instead of being tried in a state court, that actually would be tried in a federal court. Issues involving bankruptcy or interstate trade, those would all be federal courts. And the reason why we have and the reason why there's 91 federal courts is so that they're spread out around the country, and oftentimes the case will be tried in a court that is considered to be a neutral venue. So for example, let's see. So David Lee Lochner, who was the man who shot and killed and injured people in front of the grocery store in Tucson, Arizona, where Congresswoman Gabrielle Giffords was giving a speech, before he was declared unfit to stand trial, that was actually going to be a federal case. And it was interesting because different federal courts were fighting over where he could be tried. And so why would a state care about who got to try it? Probably so that they, in the end, could have bragging rights and say that they were the one who brought him to justice. As for now, he is in a mental institution in Missouri because he has been declared incompetent. But when or if he is deemed competent to stand trial, there probably still would be a dispute over which state got to, or which district court in which state would actually get to try that case.